May it please your lordship. Lordship, criminal appeal 332/2024 was listed on 21/10. Unfortunately, I could not raise the IA as I was in late in some other court. Lordship, the IA has been papered for medical ground. There is certain medical emergency. May I pray? Lordship has already permitted the IA to be listed, but it has not been listed. So may I pray once again?
Was the date fixed?
The appeal has been ordered that it will be listed after 6 weeks. Lordship.
And the IA?
If a similar order has been passed,
Then
I
we cannot, how can you change the order?
Lordship, since Lordship has passed the order,
How can you change the order?
medically
On a mention memo. You have to file a fresh IA. We have passed orders. We have to change the order. You have to file an
all right,
application.
we'll file an
File an application.
public.
It is Lordship, I beg to mention item number 13 of today's supplementary list. Lordship.
Yes.
My senior Miss R.D. Majumdar, who is the amicus curiae in this case, has some personal difficulty.
1-3.
1-3, Lordship.
Okay.
After a week, Lordship.
On a prayer made on behalf of the learned amicus curiae, list after a week. Other side inform?
Inform. Obliged.
Yes.
May it please your lordship. Lordship, I beg to mention item number 7. I'm
Yes.
appearing on behalf of Mr. R. Day. He's not keeping well. Matter may come up after a week.
He's
Okay.
amicus.
No, not amicus, private.
Okay. Mr. Bora informed.
We have been informed.
Okay. On a prayer made on behalf of the appellant, list after 2 weeks.
Obliged. Highly obliged.
May I please, your lordship? I beg to mention item number 3, my lord.
Item 3, yes.
Can it be adjourned for a week, my lord? 2019 matter, my lord.
On a prayer made on behalf of the appellant, list after a week.
Obliged.
Therefore, listing and appeal lordship and I is pending lordship and 75 years old man is custody lordship.
When was it last listed?
But I is pending lordship and the appeal admitted
I was last listed when?
lordship and for objection by the respondent.
When was it last listed?
Last listed was 25/9/2020.
Objection filed.
I have not.
Hmm?
No. But lordship,
You do not know whether objections have been filed or not.
but the party not served to me, lordship. The copy is not served. But lordship, my submission is lordship and he is 75 years old. And he is suffering from
Understood. Okay,
age-related
we'll have it on Monday next.
plot. Obliged.
Lord, I beg to mention item number 2.
Yes.
The learned amicus curiae is supposed to file an IA raising the plea of juvenility of the appellant.
Okay.
2 weeks time may be granted.
Okay.
Yes,
Other
sir.
side informed.
Yes, my lord, we have submitted that judgment.
On a prayer made on appellant 2 weeks. Appellant on a prayer made on behalf of the learned amicus curiae appearing for the appellant. Huh? Yes.
In one criminal appeal, my lord, an order was passed on the 20th of September 2023. Long back, my lord, calling for the records, my lord, and thereafter to list it. Since then, it is not being listed, my lord. So kindly, my lord.
Next week, next Wednesday.
Next. My lord, in this case, my lord, two accused appellant has been convicted.
Lordship, I have got a service report in this matter.
Conviction under?
My lord, section 6 and 10 and 11 of the Child Marriage Act. My lord.
Service report, but I couldn't find the seal of the Lordship police station. Placed there, the thumb impression of the government.
He is talking of respondent number 2, my lord, Anwara Begum.
Yes. Served or not?
Because her thumb impression is there, but I could not find the seal, my lord.
Seal of
Seal of the PS. Mikir Bhetta police.
This has been sent to you by what?
WhatsApp to my tutor, the name of that. The account of
SSC
the tutor.
council.
Yes.
Report.
But I could not.
Directed by.
could not find the info.
Husband. Person. Question ये तो वो जिसे अपने-
Husband, got it. Mujibur.
I'm not a positive.
I think
Rightly
you,
served under adult welfare.
see, it is neither here nor there. It's not that you cannot just simply, you can make a verification. And, make a telephonic interaction with him and verify it. Then we
With
can,
the IO, my lord, with the.
with the,
police
with the,
yes.
then we can appoint an amicus also, or legal aid
That's
counsel.
always there.
Heard Sri Jat Kamar, learned Senior Counsel for the appellant assisted by Sri S.J. Chaudhary. Para, also heard Miss so Para, this appeal was admitted on 25/20/24 and notices were also issued, were also directed to be issued to the respondent number 2
Too much.
in terms of the notification number 17 dated 15/24. Para, Ms. Bhuya, the learned APP, has however informed that though a WhatsApp message has been received pursuant to the steps taken on 21/5/2024 for service of such notice, comma, some more time may be granted to verify the same. Para, in the interest of justice, 2 weeks further time is granted to verify the aspect of service of notice upon the respondent number 2.
Let the date be fixed.
List on
Any date, my lord, thereafter only the hearing date.
we'll have it on 22nd,
My lord, just one more.
Friday,
That will do.
22nd November.
Can it be on 21, my lord? Thursday.
21st is a Thursday. Let it be
Just
on
one
22nd.
moment, my lord. Only verify, verification.
No,
purpose.
Thursdays and Wednesday, Tuesdays, we generally don't fix for orders. Let it on Friday.
Lord. Just try to go, try to. Well, in this case, I appear in item number 10, my lord. Because item number. आरो कागज की को luckily.
Why has it been listed for orders?
My lord, today, my lord, for that IA, my lord, actually, basically, it has come. IA is 1, 2, 3, 4. Because it was not coming for a pretty long time, then a mention was made, my lord, your lordship permitted it.
Yes.
And on the basis of that, my lord,
Conviction under
under 302, my lord, I'll give, there are 3 sections, my lord. Portfolio का,
Paper book prepared.
My
Paper
learner
book ready.
ready, but I have not been served, my lord.
Hmm.
Yeah.
Listen, paper book.
My lord, there were 3 appeals, my lord.
Just
In
paper book আছে নেকি? ইয়াতে ক'ত গ'ল? আছে?
You get the মোক যিটো দি দিলা তুমি সেইদিনাখন এটা কিবা
নহয়।
পেপাৰ বুক দিয়া নাছিলে
Well, we have not received it. Paper book.
You have got the paper book.
my lord, my testing council has received the one, huh?
Mr. Bhattacharya,
Yes, I have seen the paper book yesterday.
we'll have it maybe on Monday.
My lord.
On Monday?
Lord.
Let Leonard KP also have, and you also have a look at it. It'll be
Sure.
easier for you to, in fact, make the advance the arguments,
Right.
relate the pages and all.
After can the direction be made to the
Yes, yes,
registry,
um,
the copy by tomorrow?
Though paper book has been prepared, it appears that copies of the same
Monday,
have not been furnished to all the concerned, to some of the concerned council. Full stop. Let copies of the paper book be furnished to the council who are yet to be served with the same, and the matter be listed for orders on Monday. Monday you are around?
Monday, my lord, without respect.
Wednesday?
See, then Monday, my lord, take it time.
No, whenever you say.
No, no. please. Wednesday will be better, my lord.
Wednesday, Wednesday, madam. You-
Lordship, our name be reflected, otherwise they don't serve, even if it serves on our office, they misplace it, my lord. Personally be served on me.
Now you take care of this, names are there.
Yes, ma'am.
Name. Do not give a particular name, it will not be proper.
Because they misplace it, our office,
Why?
to the office concerned, my lord.
You take care of your office.
To Lordship, instead of parties, to the landed Lordship on the
Council.
other sides,
Planet Council has said.
for the state also.
Parties, you aren't a party.
I have a party, but
Yes. Wednesday.
Right.
Date.
নিজে নিচে পেপার বুক রেকর্ডটার আগে
Item 4 to 6.
But in this case, the other side is NCB.
Who appears normally?
No, SCCAL.
Where is he? Can you inform Mr. Kyle? He's around, his name,
It is listed Lordship.
Madam Bhuya, Mr. Das, can you inform Mr. Kyle? Conviction under what?
Under 17C and 21C Lordship and 29 Lord.
NDPS,
NDP.
commercial quantity.
Commercial.
What is the contraband?
Contraband is morphine and one powdery substance Lordship,
Chemical drugs.
chemical drug. No, to that. No, for now. What was the date? What is it? What is it? I prepared a short note, Lordship, just for
Let him come.
Lordship, please. Morphine and opium, Lord. Morphine, 54.648.
Paper book. এটাই তো কেস মুজিবুর Paperwork to be number one. এখন নালাগে সেইখনটো কেঞ্চেল কৰিছে এখন হ'ব চাগে নিউ ডাঙৰটো হ'ব সেইখন কেঞ্চেল কৰা আছে কিয় বা পিছত
Newly corrected paper book is there, Lordship.
how many appeals are there?
3 appeals, Lordship. 4 accused,
3 have come. Oh,
all 4 are before your Lordship. But in one appeal, 2 persons are there.
Ram Milan and another.
Another.
You appear in all the matters.
In Mojibur Rahman, Senior Counsel HRS will appear, Lord. And in other 2 matters, I'm appeal.
You appear for Sorab.
Saurabh Khan, Ram Milan, and Abdul Kalam. That is criminal appeal number 360 and 393, Lordship. They are inside the jail for about more than about 9 years, Lordship. Because date of occurrence is 6/5/2016.
Inside the jail as after their conviction, not as under trial.
They were from the date of arrest, they are inside.
Hmm? Any information given to
He
you?
is there, Lordship. I met him in the morning. I met him, Lord. But junior or like that. Because in the morning when I came to court, I saw him.
Next to her. Next matter appears.
He is on leave.
Somebody should be here. Matters are called upon. There is no representation. Does it look good? NCB not represented. Next to key matter. Reference. Oh, to Mihiri to Nagaland matter. Okay. Mr. Mohanta? Who is for the other side? Madam, you are there for the state. For the state. Any other parties? No.
No, only reference, my lord.
Understood. No, we but only two, both of you are there.
Fine.
Oh, wait for a while, madam. If it starts, you can come after some time. Just let's
Let him come, Lord.
let him come. But if this matter starts, it might take some time. Just wait for a while.
I'm here, Lord.
See the trend.
I have some matters, Lordship, in the
How
meantime.
long will it take, Mr.
My
Mohanta?
lord, I will not take fast, my lord.
10-15 minutes. Come,
Let me talk with Mr.
Mr.
S.
Kal.
Lord.
What was that matter? That particular act?
So what happened, my lord, 9 cases.
Yes.
This, my lord, now reference were made by the session judge. They cannot take cognizance of these matters because they are not filed by a competent person.
Correct.
So they cannot drop it also because it is not it is a warrant procedure. It is not a summon procedure. It is summon procedure at any stage it can be dropped. But in warrant procedure, it cannot be. So that's why, my lord, they, my lord, 395 CRPC, their main reference has been made. So we have to answer by the probably, my lord, by CRPC 396, my lord. So last occasion, my lord, you will have to call for the record. They admit it, my lord, in their affidavit, my lord, that it is not by the competent person, my lord.
Can copy. I see.
There is a act call, my lord, there is a,
What about your instruction that you are, that there is a talk about
Yes, my lord,
liquor prohibition?
going on. I talk on that,
No, that was your
Okay.
submission on 24/9.
but
Now,
nothing has come up. So my second affidavit, there is a prayer made. There is, as per chapter 3, 25, 26. The government has, put an notification and order by which the excise department has issued a notification, which I have also annexed, by which, it's written in continuation of this department notification, even number dated so and so 1990, the government of Nagaland hereby notify the appointment of officer in charge in all police station under section 25 and 26 of NLTP Act 1989 to function as prohibition officer in Nagaland under Director of Prohibition Nagaland for the purpose of NLTP Act. So I have made we have made a prayer, my lord, that if your lordship would permit or direct the state authority to issue same notification under section 25 and 26 of NLTP
how
Act.
can you direct? It's your prerogative.
My lord,
Court
my
is
lord,
not for to legislate.
lord.
That is your, within your domain.
Since the matter is
How
before
do
your
you answer
lordship,
the reference now?
yeah, we have to answer
It's in
that.
a very,
lordship,
condition is neither here nor there.
The-
So far as not being able to, the law not empowering him to take cognizance, there cannot be another opinion. If it is not filed by the competent person, it cannot be taken
Got you.
cognizance. But what about the other aspect? That he is not, that he doesn't have the jurisdiction to drop it also.
Yes, my lord, he can drop it.
Then what will happen?
Uh,
What will be the fate of the
And
petition?
accordingly, according to section 43, he cannot take cognizance also.
43.
কিবা এটা মানে complaint দিছিলে, complaint has to be lodged by a particular in the form of a
the
complaint.
government
It will
go ahead with the
পুলিশত তাত দিলে তাৰপিছত
No, হেৰিয়ে উদ্যোগ কৰি competent person যদি file কৰিব লাগে।
it was not filed
That
before
যদি
the
court-এ কয়।
complaint. ঠিকই হৈছে, তো next provision টো আছে drop কৰিব নোৱাৰে।
cases are mounting, no?
Yes, where is the provision? Kindly apprise us of, we
Your lordship kindly see, my lord,
just brush us the facts.
fact, my lord, 9 cases, my lord,
Yes,
they are carrying liquor.
yes,
And,
yes.
my lord, that is, they are punishable under the, there is a act called, my lord,
Page,
is, my lord, Nagaland Total Prohibition. Nagaland Liquor Total Prohibition Act 1989, page 17, my lord, of the paper book, my lord.
Nagaland
Nagaland Liquor Total Prohibition Act 1989.
Liquor Total
Prohibition Act
Prohibition
1989. That is page 17, my lord.
1988.
89.
9.
Yes, page 17.
Page 7.
17.
17. Yes.
Yes. Yes.
So under this, my lord act, your lordship kindly see this act definition, this act word and expression used not defined in this act, defined in the Nagaland Excise Act 1967, shall be have the same meaning as you are respectively assigning the terms in Nagaland Excise Act 1967, unless there is anything repugnant in the subject and context. Now, my lord, your lordship kindly page 26, my lord, section 42,
42,
42, my lord, page 26, my lord.
26.
Page 26, my lord, 42, 43, and 44 sections. These are the very important in this context, my lord.
Mm.
42. Every officer in the state government and every officer or servant of the local authority and the Gaon Buras, assistant Gaon Buras of the village shall be bound to give immediate information at the nearest police station to the any officers or the personnel authorized in this behalf of the commission of the to take all reasonable measures in their own power basis. Cognizance of the offense. No court shall the cognizance of the offense under this act unless a complaint in this regard is made by a director of prohibition or any officers authorized by them. So your lordship kindly see, complaint has to be filed by whom? Director of prohibition or any officer authorized by him, by the government. Now your lordship kindly see for section 44. Section 44, my lord.
Is the director of prohibition defined?
Yes. Yes, definition, my lord. Prohibition officer, definition 2, my lord, page 2 and 17, section 2, subsection 7. Page 17, my lord. Prohibition officer include the director or any officer or person appointed to the exercise of any of the power to perform of the duties and functions under the prohibitions of this act, and also include any officer or person involved with the any such power and on whom which may such function and duties impose and may a member of the committee or board. But here in this case, it is 9 cases, they admitted it is not by their competent in that. So now, and why it is, my lord, warrant procedure, that is section 44, my lord, penalty for the illegal import, etc. of the liquor. Page 26, my lord. Penalty. Whoever in contravention of the provision of this act or any of the rule, regulation, or order made on this person, so apparatus for the purpose of evidence only, shall on conviction be punished for each such offense which imprisonment for term which may extend to 3 years and also fine. So definitely, and CRPC 2, definition 2 CRPC, my lord, that it's a warrant procedure because it is more than 2 years. So now, my lord, tells us in a dilemma what to do. My lord,
And the other one dropping that part?
dropping, my lord, your lordship kindly see if it is a
Warrant procedure.
no, if it is a warrant, no, it's a summons procedure. At any moment it can be dropped.
If it,
That is
since
a provision, my lord.
Since it is a warrant procedure,
That cannot be dropped, my lord.
that is it. Section?
Your lordship kindly 258 CRPC. 258. Section 258.
Yes.
Has your lordship got it? 258. Power to stop proceeding in certain cases. When any summon case instituted otherwise, and upon complaint, the magistrate of the first class or with the provision of the judicial magistrate stop the proceeding at any stage without pronouncing any judgment. But in respect of my lord warrant procedure, there is no such power, my lord.
Read the entire 258.
Proceeding at any stage without pronouncing any judgment and where such stoppage of proceeding in made after the evidence of this principal witnesses has been recorded, pronouncement of judgment or acquittal in any other case, release the accused and such release shall have the effect of discharge. But in warrant procedure, my lord, cognizance has to be taken, my lord. But here, act prohibited that you cannot take cognizance because it is not filed by a competent part. So section 43 is the bar now, my lord. Section 44 of the Act, my lord, the special act. So since it is a special act, they have to be, my lord, they cannot proceed, my lord, ignoring that one. So that's why this reference made. My lord, there's a small, my lord, I have some suggestion, my lord. Your lordship kindly see 396, my lord. 396. CRPC. Three 95 is the reference. So 396, disposal of the case according to the decision of the High Court. When an equation has been so referred, the High Court shall pass such order thereof as it think fit, and shall cause a copy of such order to be sent to the court by which the reference was made, which shall be disposed of the case comfortably of the to say the cause. Here, my lord, reference was made what to do. Since we cannot drop, we cannot proceed. My lord, may I suggest, my lord, one thing? Maybe, this is my view, my lord. That, my lord, government can, my lord, withdraw this charge sheet and it can be filed from under competent officer, my lord.
How
If-
can it go in a reverse direction?
That
The charge sheet has been filed after investigation based upon a particular action by which the criminal law was set into motion.
my lord.
Now that is the act as per the Act of 1989. That is not the correct procedure. Correct
Yes.
procedure is only law recognizes that you only a complaint to be
My lord.
lodged by the competent authority, and the prohibition officer has been defined under 27, which includes the director.
My lord.
And 43 says that complaint has to be filed by the director or any officer
Authorized.
authorized by him. Admittedly, in this case, that
Not is not there. That is
that
lack.
procedure was not followed.
Not followed.
So the very initiation is not in accordance with law.
Law, correct. Correct. So now, my lord, whether he can drop it or not.
No,
So
if you-
he
it's
can-
not a
he can
question-
close it, my lord.
It's not a question of dropping. It's since the initiation is not in accordance with law,
Law that
he
can,
proceeded without any jurisdiction.
exactly, my lord. In that way also we can answer,
And
yes,
if
court
the-
can answer.
If the state is serious about this
My
issue,
lord, yes,
they can very well file.
very well, my
complaint
lord.
In
But
accordance
court
with
cannot direct.
this will be like putting
My
the
lord.
clock backward. We cannot.
My lord, my lord. That's that understand. No, that they can do it, my lord, but without direction from this court.
But the investigation has been done on a foundation which is not recognized by law.
By law, by law.
That cannot be done.
So
It has to be a
and
fresh
the entire
investigation.
proceeding is vitiated, my lord.
उसका बोला ही नहीं कि बोले তেওঁৰ হেৰি learned judge 396 ৰ কথা হেৰিটো sorry কিন্তু আমাৰ 258 তাকেতো It's asking whatever 258. Power to stop proceedings in certain cases. In any summons case, in civil sense of magistrate or any other for his there any civil sense. A stoppage of power to so far as warrant cases there it is not there. 258. And not only someone's case. It has to be one which has been instituted otherwise than upon a complaint. Would limited it. Cognizance law है cognizance law है तो cognizance law तो problem तो क्या है ना you cannot take cognizance under 43 43 of the act knowledge drop কৰিব কেনেকে section এইটোত কি হৈছে না এইটোত আমাৰ কি হৈছে to stop the proceedings at any civil proceeding and after assess of purposes made under the evidence of is stoppage আৰু dropping I think the difference you can drop it
somebody has filed a case without following the law. Law prescribes a particular
way correct
way. Magistrate and judge it is barred by section 43 of the Act as it is not filed by way of a complaint. Therefore, cognizance normally and the result will form
result কি মানে unlike a civil case return কৰি দিয়াটো হেৰি নাই না
return কৰি দিয়ে cognizance
drop হ'ব নহ'ব নেকি drop
drop of dismiss of what will be the consequence
dismissal আৰু consequence কি যাব drop হ'লে তো
drop
drop
of cognizance bar is there in 53 beleg act or
Mr. Mohanto, is it required to really come to 258? Will 258 stand as a bar? Let us read 258 of the CRPC again. He is correct so far as making the reference that so far as 43 is concerned.
My lord. No,
43 of the Act is concerned to take cognizance. It has to be a complaint by the director or any officers authorized by him.
my lord.
That has not been done. So what is the remedy left with him? He thinks that 258 comes as a bar for him to close the proceedings.
Close the
Is that correct?
It's no, that 250 is exclusively deal for the summons procedure.
Is that view correct?
258.
Is it a question of stopping the proceedings or declaring a judgment of acquittal? It isn't.
Yes, let me, my lord. 258, my lord. Again, I put it.
Please read.
Yes,
Let us read.
258. Power to stop proceeding in certain cases.
Yes.
In any summon case,
Yes.
institute otherwise than upon complaint, comma, a magistrate of the first class or with the previous sanction of the chief judicial magistrate, comma, any other judicial magistrate may, for reason to be recorded by him, stop the proceeding at any stage without pronouncing any judgment and where such stoppage of proceeding in made after this evidence of principal witness has been recorded. Pronounce a judgment of acquittal and any other case. In any other case, release the accused and such release shall have the effect the discharge. And in any other case, that portion.
Any other case means where evidence has not been recorded.
Yes.
Where evidence has been recorded, he can pronounce a judgment of acquittal. And in other cases, release the accused and such release will have the effect of a discharge. So this is what? This is not only a summons case, but it has also to be instituted otherwise than upon a complaint.
Right.
On very limited cases,
My lord.
he can stop the proceedings, acquit after if the evidence has been recorded in the meantime, and if the evidence has not been recorded, then release him, and that release would be treated as a discharge.
Correct.
Okay, now, will 258 really come as a bar for him to drop the proceedings in this case? In this case, there is a bar under 254, under 43 to take cognizance, not a bar. There is a procedure laid down how to take cognizance.
My lord.
That procedure has not been,
Has been.
so he can simply drop the proceeding. It is not a question of stopping the proceeding.
No, question arise, my lord, is the warrant procedure case.
That is it, he can drop the proceeding. Where is the bar to drop?
No, there is no mention. That's why, since in the aspect of summons procedure, it is
Summons
mentioned.
procedure, he can stop it.
But in respect of
Warrant, there is
there is no mention
there is
in
no
the CRPC.
provision.
There is no provision.
258 perhaps may not come into the way of.
Yes, yes.
He can simply see.
Yes, that
have
can be,
this-
man. That
this- This matter has come to me by this procedure. Law does not recognize this procedure.
so yes.
Yes,
that
I cannot proceed.
That way it can be answered.
And thereafter, the government.
Yes,
the
that
government-
that is open for him, but there is no in the answering in a reference matter. So only anxiety, my lord, that learned trial judge, my lord. If I proceed, then it's violation of the Species Act, section 40. So which, my lord, not prohibited, and any case it will be, my lord, they can come for causing and it will be caused. So that's why the reference, what to do. So 258 specifically respect of summons cases, but that does not bar the lordship, my lord, the answer of the court, my lord, probably.
Now, he is not exercising powers akin to 258 for a warrant case.
My lord.
This power of dropping is not akin to the powers under 258, which is meant for summons.
My lord.
For warrant case, there is no power of
No, yes.
stopping or releasing on acquitting or releasing, which would be treated to be a discharge. That is meant for only a summons case, and that too, it cannot be on a complaint. Not only summons, there is a further qualification. You see the first line, in any summons case instituted otherwise than upon a complaint.
My lord. Right.
If it is a complaint, then also if it's a summons case less than 2 years, then also this power will not come. This power is only for very minor offenses.
Minor.
It has to be a summons case. It has to be not based on a complaint. So this exceptional power is given to the learned magistrate. And if it's the chief judicial magistrate, he can do on its own. If he's a judicial magistrate, he takes the approval of the CJM. If he's a magistrate of first class or with the previous sanction of the any other judicial magistrate.
My lord.
As JMFC can do it on its own. If he's any other magistrate, he takes the permission of the CJM. And he will have to record reasons, because this power may be misused. Power from he saw this, he rightly saw 43. 43. Yes. Yes, I'm very good here. This is drop here, I got a drop in what are you about? I have to provide advice to you. And rightly, put care liquor prohibition which is harmony drop for it. Eyebrows might heavy, huh?
Later, media the opinions can be taken within
That's right. Any case law you were relying upon?
Case law in such situation, my lord, in
Two fifty-eight, what is 258?
258 and that way, my lord, actually, I have not examined, but regarding non-taking cognizance, my lord, but in certain cases, my lord, that is Telegraph
Has it
Act,
been
even in a,
explained?
even in a, my lord, Prevention of Corruption Act, inquiry has to be made by a certain officer,
Officer.
officer who are authorized. If it is not done by or unauthorized person, my lord, that is vitiated. In that way, my lord, sometimes, my lord, it is going on, my lord, the Supreme Court has set aside the judgment on
No,
without
that,
jurisdiction.
that is to the extent after judgment is pronounced.
My lord,
Here it is a case where
Become-
the learned magistrate has
Not
sought a
even taken
provision-
cognizance.
sought a provision of 42 and has raised the question that whether in such a case cognizance can be taken.
my lord. And I regarding 258, my lord, whether that can be exercised, my lord, in other cases also. Don't I have to see, my lord.
258 is applicable after taking of the minutes.
Hmm.
Once cognizance is taken, then 258 comes into it. Yeah, the question is, he has not even taken.
Right.
If it is 258, nothing.
Can we at any stage there, sir? Stop the proceedings at any stage.
Yeah. Even 250 to 3 volt. To 80, 81.
250%. Yep. Menjadi toy dong. 250 atau apa bilangnya? Jangan positif.
We should hold the very principles of taking, dropping. When it is.
And the question consequently is, will 250 come with a bar for him to take any action?
250 to no, but we 250. Nobody else. It provides certain circumstances. Stopping. Barring taking cognizance. Very good limitation. Then what do we do? It is barred by limitation cases. Business. Because there is a statutory bar. Yatev, there is a bar in taking cognizance.
Right.
Consequence would be just to dismiss it as barred by section 43 penalty period. Because no other provision of CRPC prohibits him following the provisions like
No, এটা টেউটাত পুলিচ ৰিপৰ্টত পিছত গৈছে তো এইটো ডিছমিছ হ'ব জানো
dismiss him. So ইয়াত আমি discharge কৰিব লাগিব. Discharge of
না মানে এক্সপ্ৰেছনটো ডিছমিছ কৰিব পাৰে নেকি
that is the thing. If had it been barred by limitation, what phrase we would have used? Barred by limitation, we dismiss criminal
ক্ৰিমিনেল কেছ এটা কমপ্লেইন হ'লেতো সৰি কমপ্লেইনটো বেলেগ কথা
Assuming dismiss for use, then whether the state can file a fresh complaint following the procedure, or then again this question may arise. Magistrate does not have a power to take cognizance. He cannot continue under the statute or statutory provision.
এটাত কোনো ambiguity নাই একদম এটা কি
It is
will he have the power to dismiss upon a drop মানে কি হবে
that answer we have to give actually.
সিভিল কেস হলে কোনো প্রবলেম নাছিল লিমিটেশনে বার দিছে
It is simple order barred by limitation, barred by section 53. Because 53 provides a specific mode.
We can do one thing, since you're not, you're only to answer the reference. We'll say that 258 will not even come into, we will not bring in 258. You take action in accordance with law as per 43. 43. No, let him have the expression. Thank you. Madam Groh, what do you say?
As the reference has been given to your lordship, my lord, we will abide by whatever the
No,
lordship give the direction, my lord.
that is not, you're abiding or not abiding. You don't have any other choice but to abide. But what is your take? How do you answer the reference? How do you assist the court?
It's a
See, there is no ambiguity with the uh, mode, manner prescribed in the NLTP Act of 1989 regarding how do you take cognizance.
Okay.
Cognizance 43 is very clear.
very
No
clear.
ambiguity. It's a special act. Cognizance can be taken only on a complaint filed by the director or any officer authorized by him.
By him.
Now, that manner mode has not been followed in the instant case. The initiation was by
Police,
a report before the police.
police.
And that report is, if it was by the director also, matter would have been different, but still then it would not meet the requirement of 43 because it recognizes only a complaint, not to the police. So 43, there is no ambiguity. Now the learned magistrate is concerned because he thinks that under 258 of the CRPC, he does not have the power to
My lord.
stop.
Oh, Lord.
Now, question here is that, is it a matter where you are required to stop a proceeding or pronounce a judgment or discharge or release? Is it that, or is it that because of the lack of jurisdiction or illegality in the manner which has been prescribed by law, you have to take action? 43 is a clear manner which has been prescribed, not
Right.
followed. You take action in accordance with law. Suppose which we are just discussing, there are provisions of limitation also in the
Yes.
in this code, criminal procedure code.
Right.
Complaint filed beyond the prescribed period of limitation. What does it do? Will you have the power to take cognizance? No. You will pass orders. 258 will not even come
Not
into
effective.
the way of taking and passing an appropriate order by taking into consideration 43.
Very tough.
So, go ahead, go ahead. এই সিটও বন্ধ করিবা না? ডিমলালো পানী দিব কাৰণে যদি পাহৰিছে ধৰ।
In their affidavit, they have clearly mentioned that, my lord, and affidavit filed on, my lord, 14/12/2021, the deponent state that the complaint in all the 9 cases in the incident case are not officers authorized under the section 42 of Nagaland Total Liquor Prohibition Act, nor they are covered under the notification dated henceforth for cognizance of the offense by the court.
Chamber didn't get it. No, but it is not a complaint. It has to be a complaint. Police can directly file a complaint. That's not a problem. It's a FIR requisition, report this. Who had lost the report in this case?
It lost the report, my lord. Police, my lord, constable, one is in 9 cases, my lord, defined person.
Police personnel.
Police person.
They lost before the Thana.
Yes, my lord, GR case.
Hmm?
GR case. Yes, not here. Complaint name, UBC constable, 1876. ASI, UBC. That is there.
এটা constable এটা যে detect করে detect কি করবে in purpose? Complaint to cut their idea. Director or any person authorized by him. You go to any matter of liquor prohibition. By the time complaint goes, magistrate directs for a investigation. এখন থাকবে এটা। এটা তো private case নয় যে negotiable instruments act normally effective prohibition না হবে by the time কোথায় হয়ে যেতে পারে anybody should have been authorized to not only complain, police case will be FIR. Complain হলে magistrate will take cognizance, process করি, process দিতে। What is the talk going on?
To lift up the ban, my lord.
But is it effective? With
It's,
this kind of mechanism, will it be an effective ban?
it's been going on for some time, my lord, and because of some other like organization, church organization
No,
and all this,
not on that.
lordship.
With a act of this nature, 1989, wherein it is only by a complaint where a magistrate can take cognizance, will it be an effective kind of a ban? So
is-
many technicalities have been
It
put
is
in.
difficult, my
It's a
lord.
ban in the name, nothing.
Lordship, lordship.
Practically, where will be the ban? If you require a person, director or his authorized,
Lord.
to file a complaint, by the time complaint is filed, cognizance taken, everything will be, all evidence gone. Will there be a conviction?
Certainly no.
Normally, where is the complaint case? Suppose an Act complaint case, because what is done, you cannot obliterate it. It'll be there. And it's a private person. Here, it's a complaint regarding what? Prohibition of liquor. He detects something, he reports to the director or his authorized person goes to the court will take cognizance, issue process, then court might cause an investigation. By that time, nothing is there.
Even 2051. Okay.
Therefore, those 14 weeks
Yes.
notice to be done when the current procedure of laws are applied to the police. Registered warrant procedure case. In the stage of.
That's the
When there is a bar, you cannot take cognizance. It is. It's, 258 of the.
There are many cases pending in Nagaland, my lord.
From where do you bring in 258? In the reference, is it to, is to-
Reference, man. Your lordship reference, your lordship can be. Reference was the whether a magistrate in police state start warrant procedure case can drop or stop proceeding at any stage of taking cognizance against the accused in NLPLP Act cases, since there is an express bar for taking cognizance except upon a complaint made by the director of prohibition or an official authorized by him under section 43 of this act.
Okay.
Now, 258, my lord, there is a discussion, my lord, in the order by him. He is a, my lord, a well-aligned trial judge. That's why I'm pointing out, my lord.
Page?
Page, my lord. Para 8, my lord.
Page?
Page, my lord. There is no page in it. 1, 2, 3, 4, my lord. In reference, my lord, the letter is page 15 also, my lord, your lord will get. Page 15, my lord.
Yes.
He's expressed his inability. So when the search is in file in status described in the complaint, page 15, my lord. Page 15, third para.
Just a minute, please. Only in a summons procedure.
Because of this, I give. Orders which have been.
He is a judicial magistrate, first class, Sang, Nagaland.
Analogy আনিছে হেৰি আপোনাৰ এইখনৰ Section 22 of the Transplantation of Human Organs Act 1994, page 11. Then Post Office Act 18. নাই সুপ্রিম কোর্ট এইটো ট্রান্সপ্লান্টেশন কেসত কিন্তু হেৰি কৰিলে লটো মানে পেজ 11 Into paragraph, your inhibition to 50 page 15 of page 15. Take the next paragraph. 258 discuss করার পিছতে will not come at all.
You have not even taken
Cognizance.
Initial burn us. Because unless and until it takes cognizance of the stopping will come when you traffic them. It's starting from that line.
No, without going to the 258, applying only that particular act, you can drop it, man. Because since it is one procedure, that's why 258 comes.
Unlike someone's case, so where do we get the power to stop? But you're not required to pass orders of stopping.
Cannot
Cognizance.
take
Okay. Heard. T.J. Mahanta, Learned Senior Counsel, assisted by P.P. Das, Ms. P.P. Das, for the Guwahati High Court.
My lord.
Also heard Ms. T. Crow, Leonard. Your AG, AG. AG, State of Nagaland. Hearing is concluded, judgment is reserved.
My lord, please.
Looks like I didn't go get it. Yeah, they did.
My lord, if I find any judgment in 258, my lord, I'll
May I please, Lord? Lord,
Please,
please, we'll appeal, my lord.
Not could I put it on? Not. Mr. Das, you are the PP. Ready with the matter?
Otherwise, ready.
Mr. Tiwari, amicus.
Yes, my lord.
Section?
302 and 322. Well, here in this case, my lord, there is an injured eyewitness also, who is PW4, my lord.
Yes,
And-
please.
And my lord, the conviction is basically based on the testimony of PW3 and PW4, my lord, along with the, my lord, deposition of the medical officers, my lord. Only this one. Very short, my lord.
Please read the FIR.
Yes, my lord. The FIR is at page 4, my lord.
Page 4.
Page 4, my lord.
Yes, please.
I have the honor to state that around 11:30 p.m. on 14/12/2009, I, along with my maternal uncle, Munu Hassanu, was going to his house at Kheroni from my house at Manja PWD colony. Before we reached his house, a person named the accused appellant, my lord, this Talon Thousand, suddenly punched me on my right eye, causing grievous injury to me on Kheroni Road, and also assaulted my maternal uncle with a sharp weapon, causing grievous injuries to him, as a result of which he died at Tifu Civil Hospital while undergoing treatment. I therefore pay to you to take necessary legal action in this regard and apply. So the FIR was filed on the next day, my lord, next day of the incident, my lord, immediately. My lord, at page 6,
Just a minute. Yes.
Page 6 is the charges framed by the learned district judge, my lord.
Atish Ajit. What is his name? Atish.
Atish, my lord.
PW4.
Atish Nikku, sir. Yes, my lord. Is
PW4.
PW4.
Informant is PW4.
Yes, ma'am.
Yes.
Now, at page 6, my lord, the charges were claimed by the learned deputy commissioner, my lord. Since, my lord, by that time, my lord,
No
the
problem.
judiciary and the executive was
Yes,
not
yes.
bifurcated, my
No
lord.
problem.
So, on two heads, my lord.
Hmm.
Page 6, my lord.
Hmm.
First, that you on 14th day of December 2009 at about 11:30 p.m. at
Yes.
Keronigaon. This was under T23, my lord.
Okay, you can proceed to the.
Yes, madam. Now, my lord, would kindly see at page 9, PW1.
Who is he?
My lord, he's a villager, my lord, co-villager, my lord.
Hearsay.
Yes, my lord. Complete.
Yes, next.
Next is PW10, my lord. Same hearsay, my lord.
PW2.
PW2, my lord. Page 10.
Yes.
Now, PW3, this is it, what? Like, he was the person who took the disease to the hospital, my lord, from the place of occurrence, my lord. Page 11, my lord. Married, my lord. I know the complainant and the accused. I also knew the deceased. The incident took place in the year 2009. At about 11 p.m. on that day of the incident, I was sleeping after having dinner. At that time, my wife woke me up. So, my lord, this is important. And told me that there was a commotion near our house and asked me to go there to inquire what was happening. I got up and went to the place of occurrence, which was 200 meters away. On reaching the place of occurrence, I saw deceased Munu Hasnu lying on the ground beside the Kacha road. I recognized him as he was my brother-in-law, wife's brother. Though he was not dead at that time, his condition was very critical. I saw blood oozing out of the back of his head. Thereafter, I called the people residing nearby the place of occurrence and brought Munu Hasnu to my house. This is again important, my lord. Thereafter, the people of my neighborhood called an ambulance over phone. After 15 minutes, the ambulance reached my home and I, along with three boys of our village, took Munu to this Difu hospital. We reached Difu hospital at around 11:30 p.m. The doctor immediately started treatment. Thereafter, around 3 a.m., Munu succumbed to his injuries. Meanwhile, somebody from the village informed Manja police station and police arrived at around 7:30 a.m. and brought Munu to Difu Civil Hospital. Thereafter, postmortem examination of the disease was done in the hospital itself and around 1 p.m. we took Munu Hasnu's dead body to his house at Keroni and cremated there. Later, I heard from people of the village that accused Talon Thousand has assaulted the deceased to death. So, my lord, this is again very important. Now, cross, my lord, I did not witness the incident of assault. I do not know whether the deceased consumed alcohol on the day of occurrence. The deceased has no illness before his death. The relationship between the accused and the deceased was cordial and there was no quarrel between them. So, my lord, this is again important, my lord. He also says that my co-villager, because he's a teacher by profession, my lord, this PW3, my lord. So he says that there was no previous enmity between the accused and the deceased also.
Now, this is PW4, the injured eyewitness, my lord. This is important. Now, my lord, one more thing I'll just point out to your lordship, my lord. This PW3 name is shown in 3 different words, my lord. Somewhere it is shown as Bonilal. In the charge sheet, he is shown as Ponilal, and in the, my lord, deposition of this PW4 is shown as Panilal. But it's the same person, my lord. I'm reading, my lord, the PW4, my lord. I am the complainant in this case. The incident took place about 10 years ago. On the day of incident, my maternal uncle, deceased Mama, Munu Hasnu, came to pay a visit to our house. So the deceased only came to their house, my lord. At around 11 p.m., my maternal uncle and I were going from our house to his house, which was situated 1 kilometer away from our house. We were going along the PWD road, and at that time, accused Salon was following us. And without any rhyme or reason, the accused punched on my right eye. At that time, though I was suffering from eye pain, the accused again assaulted the deceased with a lathi stick. This is important because in the FIR it is sharp weapon, my lord, on his head, whereupon the deceased fell down beside the road. Thereafter, I came to my uncle, mother's younger sister, husband, Ponilal Diffuser. Here, my lord, the word Ponilal is shown as Ponilal, my lord, and called my aunt, mother's younger sister. Then Ponilal Diffuser came out and I told him about the incident. Whereas PW3 says that only his wife informed about the commotion, my lord. Later, I, along with my uncle, mother's younger sister, husband, and aunt, came to the place of occurrence with an earthen lamp. Whereas, my lord, PW3 says that he alone went to the place of occurrence, my lord. Thereafter, he called the villagers, my lord. Villagers came and thereafter he brought the body to their house. I left my uncle with the deceased, who was in an injured condition at that time, and again came to uncle's house. Later, my uncle, Ponilal Diffuser, and the villager called a 108 ambulance, and after arrival of the ambulance, my injured maternal uncle was taken to Diffu Government Hospital. I also came to the hospital as I sustained injury in my eye. Thereafter, at around 3 a.m., my maternal uncle Munu Hasnu died in the hospital. Thereafter, Manja police came to the hospital and conducted the post-mortem there itself, and the disease was taken to his house and cremated. That day, I lodged an ejar with Manja police station against Salon Thousand in connection with the incident. The accused is present in the court today, assaulted the deceased and me on the day of incident. Exhibit 1 is the ejar I lodged, and Exhibit 1.1 is my signature. I came to the Diffu court and gave my statement. Exhibit 2 is my statement. Exhibit 2.1, 2.1, it should be 2.2 are my signatures. Now, my lord, cross. This is again important, my lord. We did not have any quarrel with the accused. We means he's saying the maternal uncle as well as himself. It was around 11 p.m. when the incident took place. There was darkness at the place of occurrence. Although the place was within one's calling distance, nobody came out. Now we do not have any quarrel with the accused. It is not a fact that accused assaulted neither me nor the deceased on the day of occurrence. So, my lord, even we take the evidence of PW4, what would highlight to that, my lord? As per PW3's version, my lord, it was his wife. Even we take PW3 because they are related otherwise, PW4 and PW3. But if we take independently the evidence of PW3, my lord, what transpires is that, my lord, his wife, after hearing a commotion, my lord, informed her husband that you go out, see, something is happening. And on the strength of that information, my lord, he went because he was sleeping. But, my lord, in his deposition, neither he says that.
What was the time?
It was around 11
in between 11, because the informant says that incident occurred at 11. Night at 11, my lord. So, my lord, on the information of the wife, he went out. Neither he saw this PW4, because as per the version of PW4, he came to the house, informed his aunt. Thereafter, he, along with the aunt and the uncle, went to the place of occurrence. Thereafter, he left his uncle there and came back home. And thereafter, the uncle, along with the villager, called the ambulance and took the hospital. Whereas PW3 says that on the strength of the information from my wife, I went to the place of occurrence. He did not find anybody there, my lord. Thereafter, he called neighbors, my lord. The neighbors came, brought the injured to the house, and from the house, the co-villager called the 108 ambulance, and from there they took, my lord. So even by going by the evidence, my lord, now last seen theory is not there with this accused appellant, my lord. It is with the informant only. Now, my lord, the previous enmity is not been shown in both their evidences, my lord, to show that this accused appellant will anyway assault the deceased, my lord. Third is that the wife was never examined in this case, my lord. Fourthly, the place of occurrence, there were other 3 houses also. Those people were also not, my lord, otherwise called as witnesses, my lord. Mainly on the deposition of these 2. And the vital aspect your lordship would find in this case, my lord, the alleged weapon of offense is not recovered, my lord.
But how do you discard PW4?
This is what, my lord, for this, my lord, I am saying. First is that he is injured. And he is injured by, he says, a fish blow was there. Now the medical report of this eyewitness is there. The doctor said that it is by a blunt weapon. My lord would kindly see the medical report at page 86 of the paper book, my lord. Page 86 of this informant, my lord.
First, let us finish the other
Yes, my lord.
evidence.
Yes, my lord. Now, my lord would find.
Just a minute. Relative. Page 11. How was the death caused as per the PM report?
Sharp weapon, my lord.
Sharp weapon.
And the informant says that a lathi and a single blow will be. In the deposition in the court, my lord, it says that he was assaulted with a lathi on his head. Thereupon the deceased fell down beside this. And he has not stated that there were repeated blows, my lord.
Yes,
Now, my lord, PW5, my lord.
it's 15.
Yes, sir. Now, my lord, he is the brother of the deceased, my lord. The complainant is my nephew. I know the accused. This is Monu Hasnu was my brother. The incident took place in the night of 14 December 2009. I was at Manja in the night of the incident. At that time, some people of my village, Karoni, came there and informed me that the accused has assaulted my brother, Monu Hasnu, causing grievous injury to him. After receiving the information, I came to Diffu Hospital on the following day of the incident and found him dead. After reaching hospital, I came to know that the accused has assaulted the deceased with a dagger-like dagger, and I saw the injury on the back of his head. I noticed that a number of his teeth had fallen out. The accused has assaulted Atish Diffusa on his eye, and I noticed swelling in his eyes. My brother Munu died due to the injury caused by the accused. Now, hello.
Artist is PW4.
Yes, Atish is PW4. Now, cross my lord, page 16. I heard in the village that the deceased and the accused together consumed alcohol in the night of the incident. It is a fact that the deceased died as a result of assault made by him to the accused. I did not witness the incident. Whereas, my lord, this complainant, informant, and injured eyewitness, he says that he came to our house and thereafter I was dropping my maternal uncle to his house. So we were walking towards his house. And this sketch map also shows that their house is my lord. So my lord, meaning thereby that he did not say that he had consumed alcohol with the accused appellant, my lord. This never came up. Now he is an interested witness, to my understanding, my lord, PW5. That is why otherwise he's pointing out that, my lord. Because the only person, if we take him as an independent person, PW3, my lord, so he has deposed fairly but he has hided the person who committed the offense, my lord. This is what he has hided from the investigation, my lord. Because he being his own wife's elder sister's son, that is why. Otherwise, my lord, there is no any hit of evidence against this accused appellant to show his role and participation in the commission of the alleged murder, my lord. Because neither last scene is there, neither weapon is there, nobody else, my lord. The place of occurrence, there were 4 houses, my lord. None of them has said anything about that. And a house situated 200 meters away, my lord, they hear the commotion. Whereas the place of occurrence is, I take your lordship to this sketch for a moment, my lord. My lord would better appreciate this matter, my lord. Page 80. For a moment, my lord.
Page
Page 80, my lord.
80.
80. Sketch map.
Yes.
Now, my lord, A is shown to be the place of occurrence, my lord. And D is shown as the house of the PW3, my lord. Then, my lord, B is of one Ranjit Bodosa. Then, my lord, C is the house of one Jagar Singh Diffusa, who is not examined in this case, my lord. E, Anita Bodosa, is also not examined in this case, my lord. F is the house of the accused appellant, my lord. And G, my lord, thereafter. G is the
Yes.
house of the deceased, my lord. E, B, C not examined in this entire case. And neither the 3 boys who took neither the three boys who took the my lord, injured to the hospital, those are all not examined, my lord. The neighbors, as per PW3, the neighbors who came, my lord, who brought the injured to the house of my lord, Poni Lal, my lord, those were also not examining. It creates a reasonable doubt in mind. There has not been a fair investigation. And innocent has been. And this accused, my lord, fairly have replied in the 313 that he has not. The other part, the learned trial court has taken to convict the person was.
No, leaving aside the, brushing aside the other.
Yes.
See, if there is an eyewitness
Yes, ma'am.
who himself was injured, we have to test his veracity. Eyewitness sole testimony will be enough to sustain a conviction. Eyewitness, and that to injured witness. His evidence, the credence upon such evidence is more. Now, is his evidence, he was also the informant.
Then, my lord, my next submission would be that since we came out of the house, might be we have come, these two have consumed alcohol, my lord. There was a tussle between them, my lord. Now he has only received a single blow on his eyes. So, my lord, if I'll have a fight with somebody, then only I'll have a blow, my lord. If I'm assaulting somebody,
What is his age?
my lord,
Age?
the diseases,
Informant.
informant age 22, my lord. And the diseased age is also 22. That apart, my lord, why I'll only make a fist blow on the eye of the injured and make severe blows on the.
He may have an enmity with the.
That has not come on record, my lord. This is what the important aspect is, that
Is it
something.
necessary that why one to fist, one to the. That cannot be a reason.
Because, my lord, I would never be knowing that somebody is at a house of somebody. In fact, if at the morning hours or a day before or 15 days, 10 days on the same day, if there has been something, then, my lord, it is not a case I have been following the person. But that previous, because, my lord, somebody, two persons are going on a road, my lord, why would a third party would go and assault, my lord? Neither for money, neither to loot them, my lord, nothing is there. So, my lord, a reasonable apprehension has to be brought, my lord. Why he assaulted, my lord? Because nobody has seen. Nobody has seen him running away. And in fact, the PW3 and the wife, PW3 never says that the PW4 came and informed my wife, and thereafter we along with him went, my lord. This is missing. The vital aspect is missing, my lord. Neither he went with the two at the place of occurrence where the injured was lying. This statement is also not there, my lord. Because as per PW4, first he informed his aunt. Aunt informed the uncle. Thereafter, all three, along with an earthen lamp, went to the place of occurrence, whereas PW3 says he alone went there. Because the aunt says that there is a commotion, you go and check. So only on the commotion he went there. And had on the commotion he went there, he should have definitely seen the assault and he should have definitely met the PW4, which is missing in the evidence, my lord.
See, you have said that his house is at a distance of 200 meters.
Yes,
200 meters.
200.
Night 11 o'clock. Let us assume that he hears some commotion. And as the evidence is that only one blow.
Yes.
Is it necessary that he goes and still the fight is continuing?
No, I'm not on that point, but I'm leaving aside that part. My only aspect is PW3 must should have stated that I met the informant. Or otherwise I had any interaction. Or even he spoke me that so and so has assaulted. Now he says he hears from the villagers that he's assaulted. Kindly see. Once again, my lord, PW3 PW3, page 12, my lord. Once again, I'll read out.
Vital to PW3 and PW4. PW4 যদি PW4 যদি অকলে সি সাস্টেইন কৰিব পাৰে। Yes, let us proceed.
Yes, my lord. Now, my lord, page 17, my lord.
70 is what?
My lord, the PW6 was the doctor who conducted the postmortem, my lord.
Yes, yes, just a minute, please. See PW 5, for fifth line from the bottom.
Yes, my lord.
Of course, we'll read the medical evidence, but fifth line from the after reaching the hospital, have you got?
Yes, my lord.
I came to know that the accused had assaulted the deceased with a dagger like dao, and I saw injury on the back of his head.
Yes.
I noticed that a number of his teeth had fallen out.
Correct.
Why we are trying to, because on the use of the weapon, sharp weapon, lathi. Let us see what, we'll see what, let us see the PM report.
Yes. PM report, my
External
lord.
injuries at page 75.
Yes, my lord, page 75, my lord. The injuries are defined at page 76, my lord.
Yes.
A male dead body with bandage of head and face region examined. The deceased has multiple cut injuries with clear margins, skull wound, lacerated wound with fractures, multiple lacerated wound on face, neck, and head region.
Skull skull is fractured.
Skull is fractured. Lacerated wound with fracture, my skull. But that is on the back side.
No, skull bone.
Skull bone. Number 2 says that, my lord, skull perpetrated sharp cutting wound of skull and skull bones, capping of the skull wound seen. Brain and spinal cord, intact brain matter. Other particulars are intact, my lord. Now, with page 78, my lord, multiple cut wounds with clear-cut margins are seen over the face, neck, and skull. Wounds are stitched and bandaged while examined. No brushings or abrasions of margins seen.
The Sarvavan put quiz. In my opinion, that is due to multiple laceration, wounds leading to shock and hemorrhage. Sharp one and fracture also. Sarvavan cut hobo. Fracture hobo pare. এটার বুকুটও আছে যদি abdomen was a lacerated injuries. Multiple step injury with clear cut margins. Penetrating injury of skull bones.
But my lord, the eyewitness never says about multiple those in the evidence to the court. He only says a single blow with a lathi. Then where from the other injuries will come?
Where was the appellant apprehended?
From the house as per 313, whereas the IO says that he was from the jungle, from the forest, whereas in the 313 the accused himself replies that I was arrested from my house, because in the examination of the
House
IO,
when? Which date?
same date, my lord.
Same date means it was very night.
It,
late in the
it
night.
was on 15th in the early morning, 3 a.m., my lord.
Because the incident happened on 14th at
14th
around
and
11
15th,
o'clock.
early morning 3 a.m. he was arrested from his house, my lord.
Also died here.
বিহার অবজাত রাস্তা তৈরি করেছে মাঝে জায়গাতে প্রবল শোভা নাই দেখে দিই এটা করে সাহেব করবেন বিষয়টা সুকুট মানিতে রাখবেন PW3 এর কথা একদম ইগনোর করে বললেন PW6?
PW6 is, my lord, the doctor who conducted the post-mortem, my lord.
Yes.
On 15/12/09, I was attached to at Tifu Civil Hospital as senior medical officer, health officer. On that day, I conducted post-mortem of the deceased Munu Hasunu brought by C62 Baburam Pro in reference with Manja PS system number so and so. found the following external appearance: a male dead body with bandages over the head and facial region. The deceased had multiple cut injuries with tear marks, skull bone fractured, lacerated with fractures, multiple lacerated wounds of chest, neck, and head. Sharp cutting wounds of skull bones was found with cappings, brain matter intact, all internal organs NAD. Detailed description: injuries described as above. Opinion: in my opinion, the death is due to multiple lacerated wounds leading to shock and hemorrhage. Exhibit 3 is the PM report. P1 is my signature. P2 is the signature of the superintendent of Diffus Civil Hospital. Exhibit 3 is the signature of the Joint Director of Health Services, Karbi Anglong, Diffus. Injuries sustained due to sharp cutting weapon. Now, my lord, this PW7 is otherwise important. Is the IO. PW7, my lord, Ishwar Singh, the investigation officer.
Yes.
On 15/12/2009, I was posted at Manja police station as officer in charge. On that day, one Atish Diffusa lodged an FIR before the Manja police station. Accordingly, I registered a case being Manja PS case number so and so under section so and so. Exhibit 1 is the SR. Exhibit 1, 2 is my signature. Immediately, I went to Diffus Civil Hospital along with my staff and complainant Atish Diffusa. I saw the dead body. Now, Lordship would kindly note, I saw the dead body of the deceased Munu Hasnu at the Diffus Civil Hospital. I inquested the dead body in presence of the witnesses. I sent the dead body for postmortem. Then I went to the place of occurrence and drew a sketch map of the place of occurrence. Exhibit 4 is the sketch map of the place of occurrence. Exhibit 1 is my signature. On the day 15/12, I apprehended the accused Salem Thousand from the forest area of Keroni. I searched the house of the accused Salem Thousand in presence of him and searched for the dove which was used at the time of occurrence, but I could not find the said dove as the accused has thrown the said dove in the jungle. Then I brought the accused to the police station and interrogated him. The accused confessed before me that he assaulted the deceased on the day of occurrence. On the same day, 3 p.m., I arrested the accused Salem Thousand. On the next day, 16/3, I forwarded the accused to the Honorable Court and prayed before the Honorable Court to give accused to police custody for 5 days for searching the dove. But the court allowed 4 days police custody of the accused person. When we searched for the alleged dove along with the accused person, but we were unable to find the dove which was used in the alleged incident by the accused person. I prayed before the Honorable Court to record the statement of injured Atish Diffusa, and the Honorable Court recorded the statement. I collected the postmortem report of the
Atish,
deceased.
there is 164.
Yes, that is it.
Let us see that.
At page, my lord, you find 173, my lord.
Yes.
On 14/12/2009, Monday, I came from my home at Keroni Gaon near PWD camp to drop my uncle Monu Hasnu at his home at Keroni Gaon. It was about 11 p.m. As we were about to reach the village, one person, Salem Thousand, suddenly came and hit me in the right eye with his fist, and I fell down. Then Salem Thousand hit my mama, Monu Hasnu, with a dao several times. I saw the incident, and out of fear, I ran away and entered my uncle's Moha house. His name is Ponilal Diffusa. My uncle was asleep at that time. My auntie woke him up and 2 others. And we went looking for my mama. We went looking for my mama, Sri Monu Hasnu. Monu Hasnu was grievously injured in the face and head with cuts by dao in his face, tongue and head. Some of his teeth were lying on the ground. We picked him up and took him to my uncle's house. My uncle Fanilal Difusa called the ambulance. The ambulance arrived and the injured was taken to Difu Civil Hospital. I stayed in my uncle Fanilal Difusa house. Later on, we were informed that Mama Hasnu expired.
See, he gets a fist blow on his eye. He falls down. And out of fear, he runs to the house of his relative, PW3. He doesn't say that after seeing that blow, the deceased, the appellant had left the place.
He did not say so. Next part is that this PW3, I'm taking PW3 as an independent witness in this case, my lord, not as his Moha. But that Moha never says of meeting this informant, my lord. This is what creates the doubt in my mind. And neither the Mahi is examined, my lord, the one who woke up. And this informant says that along with this 3% he went to the place of occurrence, whereas PW3, even taken independently, my lord, he says that he alone went there, my lord. And along with co-villagers he brought, he never speaks about this informant in his entire evidence, my lord. Entire evidence. He never even says about the injury on the PW4. Because that is why I'm taking PW3 as an independent witness, because he does not even say about injury on the.
Is there any medical report of PW4?
Yes, there it is there, my lord.
Let us see.
Yes, my lord. At page 86. And this doctor was also examined, well, SPW 8.
Please read. Injury day 1512. KK Bur was examined
Yes, my lord.
as
My lord, PW 8, my lord, page 21.
PW8.
Yes, my lord.
Okay. Yeah, 164 is consistent with his FIR. এটাই বুঝে না পারলাম এই নিজে ইনজিওর্ড হওয়া মানুষকে এবার লাঠি কইছে মানে আমি বহুত লাঠি বুলি বললাম If I was it, I would think the informant of it. It had been somebody else's informant who did not see. He is the witness. He wrote the affair. He says it was a sharp weapon. Sharp commissioning. Sharp weapon. Weapon. Sharp weapon.
Married PW 8.
Yeah, just a minute. Yes.
On 15/12/2009, I was posted as Diffuse Civil Hospital as IOPD. On that day, I examined injured Atish Diffusa, age 22 years, so and so, in reference to Manja PS case number so and so, and found the following. There was history of assault yesterday. On examination, I found right upper lid, oedema, and abrasion over lateral aspect of size 2 cm into 1 cm, vision 6/6, injury. Remarks, injury was caused by blunt weapon. Exhibit P6, P8 is my report. Exhibit P6, PW8 is my signature. Cross, my lord. I examined the injured Atish Diffusa on 15/12/2009, but in my report, I had mentioned the date wrongly as 15/12/2010. The date in my signature was overwritten, and Manja PS number 52/2009 dated 15/12/2009 is also overwritten. I had not mentioned in my report about the alleged history of the incident. The victim did not tell me how he sustained injury or who assaulted him. The victim also did not tell me what kind of blunt weapon was used to assault him. So even otherwise, my lord, I have sustained an injury. I'll go down to the doctor and spell out how I have sustained the injury.
No, before the doctor is not necessary that he'll name somebody.
But even
It's
otherwise,
not the police authority.
but even going by the injury, even the doctor will definitely ask, how come you have sustained this injury? Then I'll definitely reveal. Because at the time of treating for an injury, my lord, definitely either the doctor or the patient is going to speak about the injury, my lord.
The doctor, on a regular basis, they treat so many patients. And now this deposition was made in the year 2022. You have to see all the aspects, practical aspects. The examination was done sometime in the year 2009.
My lord,
After
That,
12
my lord is
years,
correct, my lord is
how
correct.
do you
my lord.
remember?
Yes, my lord, because it was almost, my lord, 12 years
These
after. my lord.
these are official witnesses. They'll just see the record and say whatever is
Correct, my
there.
lord. After 12, 13 years, my lord, deposition is
That
made, my lord.
is a lacuna in our
But-
system.
Then, my lord, the 313 was taken. The question number 21 is important, only, my lord, to my understanding. The accused himself says that he was arrested from his house, home, my lord. Page 31, my lord, the 313 question number 21,
Page.
31, my lord, 31
Okay.
of the 313, my lord.
Page 31.
31, my lord, question number 21, my lord.
Yes.
PW 7 Sri Ishwar Singh has stated that on the same day, 15/12/2009, he apprehended you from the forest area of Keroni. Have you anything to say in this regard? Yes, I was arrested by police from my home. He admits that he was arrested from his home, my lord, not from the forest area, as stated by the IO, my lord. And my lord, case 34, the explanation.
It is a false case.
This is the first case. I do not know the injured and the deceased person. Atish Diffusa has assaulted his uncle, Manu Hasnu, and falsely implicated me in this case. I had no enmity with the deceased Manu Hasnu and Atish Diffusa. I did not know the deceased personally. He was just my co-villager. And this is what comes out from PW3 also, my
What comes out from PW?
my lord, that this person was not there. He's in, because my lord, had the version of the injured eyewitness had been corroborated by PW3, my lord, I did not had any case, my lord. But that PW3 has nowhere stated that he even met, or he did not even in his entire examination spell about PW4, my lord. This is
How
something
many
surprising.
164 statement were recorded? Only one.
Only one. And the PW on the strength of the evidence of PW4, PW3, and corroborating the, my lord, the evidence of the medical officer.
Where is? Hmm. PW5 was in again. 5 was page 15. Close up this. 16. Yes, formulate your grounds.
My lord, my first ground is that the eyewitness could not corroborate his version with the other witness, who otherwise have been found to be there at the place of occurrence after the incident.
Not at the place of occurrence. Except the PW4, none was there at the place of occurrence. See, visiting the place of occurrence later is not, that's a different, it's a different footing.
So, my lord,
Being present at the place of occurrence indicates or means that he was an eyewitness. Going there later, everybody has gone to the place of occurrence later.
so, my lord, my first argument would be that PW3 has not corroborated that PW4 came to his house and informed his wife about the incident.
How much corroboration is required for an eyewitness? Injured eyewitness.
That is, my lord,
Requirement
different,
of
because
corroboration.
last night, my lord, I was seeing the, my lord, the judgments, my lord, wherein, my lord, the weightage of an injured eyewitness is much higher than, my lord.
So the only scope avenue left for you is to discard this PW4 by his own conduct. What is his conduct in lodging the FIR while he has deposed in the dock,
Yes.
while he has made his statement under 164?
Oh.
This is the only scope you have.
Only scope to
Even if you leave aside all the witnesses,
all the witnesses.
star witness, eyewitness, one can be convicted. But whether it is a trustworthy eyewitness,
Then, my lord, I have only one aspect to place for your lordship, is that in the FIR he says about tar paper, my lord. In the 164 he says about tar paper, but in the court he speaks about
Lathi.
lathi. In 164 he says multiple blows were there, whereas in the FIR he only says of a single injury, and in the deposition for the court, my lord, he says about a single injury or a single blow. Only assaulted my maternal uncle in the FIR with a
FIR
sharp
has
weapon.
not said one
No,
assault,
not
two
one,
assault.
my lord, but he says only
An
also
FIR
assaulted my maternal uncle with a sharp weapon.
An FIR, as you know, is a brief,
Yes.
very
No,
brief
it is not brief.
description.
But in the 164 he says, my lord, in the 164 at page 73, my lord, that he hit my mama Monu Hasnu with a douse several times. But while deposing in the court, my lord, he only says with a lathi.
Where is 164?
164 is at page 73, my lord.
73, right. Twenty-one, 12. 2009. 2009, correct?
Yes, my lord.
On 14/12. West, very down. Several times. Witness box क्यों है मेरी कोई ले? Witness box क्यों है चिंची कोई? They will use a weapon also. Use a weapon, look at my I think the case is very important of the involvement of still later. The death is by use of certain weapons. Some of the witnesses want to be to you doubtful way. Okay, we'll come back at 2 o'clock.
My second submission would be contradiction as to weapon, my lord. Because, my lord, in the FIR as well as in the 164, my lord, the informant speaks about sharp weapon, whereas in the court deposition, my lord, he speaks about a lathi, meaning thereby a blunt weapon, my lord.
This is mainly in connection with the deposition of PW4.
Yes, sir.
Contradiction regarding the description of the weapon made by the PW4 in his FIR in 164 and as a witness in the doc.
Now, my lord, the injured eyewitness PW4 also did not state that the accused was carrying the weapon with him. I'm just making this submission because, my lord, the other reason for this is, my lord, if I'm carrying a weapon, my lord, and I'm assaulting first to the informant, then to the deceased, my lord, then I could have made the blow with the weapon only to the accused informant also. Why would make a fist blow to informant and thereafter with a sharp weapon to the deceased, my lord?
At 11 o'clock in the night, you may not be able to see, and he may have
But even
it's a
otherwise,
matter of chance that you were hit by the fist. This was hit by the dao or
but,
whatever.
my lord, my respectful submission would be, my lord, I'll use my right hand, even if I'm a right-hander, my lord. So if I'll use my right hand, then, my lord, otherwise from the weapon also I'll struck from the right hand, and even if I'm required to make a fist blow also, I'll make a blow with my right hand only. So meaning thereby that by the time if somebody is assaulting me, my lord, I'll at least see what he's handing. So, my lord, neither
No, it's
the
not a case of dacoity that each of the persons had to be attacked. He wanted to kill the deceased. And so far as this PW4 is concerned, he was given one blow just to take him away. Otherwise, if the intention was to kill both,
And my lord, the other submission is the informant could not even show the previous enmity between the deceased and the accused appellant, my lord.
No animosity could be
Yes.
proved.
Last submission, my lord, I'll come up by saying so, that the presence of the eyewitness is not even corroborated by PW3.
That you have said,
But this is my-
PW3 has
my
not
lord, this
corroborated
one.
before.
This one.
You said something about the weapon was not seized.
Yes, my lord.
No
the weapon was not
serological,
seized.
no serological
Not
test
no
done.
surgical test, my lord. And my lord, last part, my lord, the injury was simple. As far as doctor is concerned, the injury in the eye, that was simple. So it did not have that much of impact that the other assault he could not see. Or he could not define about the weapon, my lord.
11 o'clock
11.
night. Even without an injury in the eye, you will not be able to see.
No street light.
And
Because
those are
PW3 says that
rural areas.
they carried a earthen lamp to
Earthen
see,
lamp, rural
to reach the
areas.
place of occurrence, my lord. That part is there, my lord.
Manja.
Yes.
Then what was this place?
Keroni, my lord.
Keroni. And that to December.
And it is the last part of
11
December.
o'clock December night.
Last part of December, my lord. And the age of the appellant is 19. From the 3135 calculate, it is around 19 or 20 years by the time he assaulted, my lord.
At the time of the occurrence.
Occurrence. And the disease and the informant are 22 years old by the time the assault was committed. My humble submission is that, my lord, the prosecution failed to prove this particular case beyond reasonable doubt, ma'am. And since some of the vital witnesses, the neighbor, did not corroborate that there was a commotion or they heard something, that is also missing, ma'am. So there was a defective malware investigation in this case, ma'am. Because this sketch map even shows other 3 houses also there, my lord, near the place of occurrence. But those 3 houses, persons were never examined, my lord, in the court to bring on some light to the incident. And there are chances that there might be a tussle between the informant and the deceased, my lord, because they were the only person, as per his version, they were the last person who were together. Whereas in fact, nobody else.
That you cannot
After-
just, no, that presumption you cannot raise here.
Yes, my
There has
lord.
to be
That I
some
could I could have
There has
taken
to
it
be
in
some
the trial court, my lord.
some foundation
Some in
in
the
the
trial.
cross-examination.
I could have taken those things in the trial court.
After the evidence is over, that will be not proper.
This is my humble submission. Deeply obliged.
So Das?
I want to submit lordship in my humble submission. The date for 302 is because of he succumbed to injuries, Lord. Firstly, I want to focus on that point, Lord. Moreover, PW3 talks about there was a commotion. It is there, Lord. Woke up at about 11 p.m. on the day of the incident. I was sleeping after having dinner, and at that time, my wife woke me up and told me that there was a commotion near our house. So some kind of altercation or quarrel is there, Lord. Moreover, if we look into the 164 statement, Lordship, I want to focus on the injuries, Lordship, and the medical report, Lord. May I read, Lord?
Please.
Then stolen thousand hit my mama, Monu Hasnu, with a dao several times. I saw the incident and out of fear, I ran away and entered my uncle Moha's house. So I want to clarify here one thing, Lordship. He have seen everything. After that, he ran away. because I am stating that because he described the what were the manner, in what manner the injuries were there, Lordship. He first saw, then he ran away. I saw the incident, that is the point, Lordship, and out of fear, I ran away and entered my house, so and so, Lordship. His name is Sri Panilal Diffusa. My uncle was asleep at that time. So and so, I want to focus on the Lordship injuries. Monu Hasnu was grievously injured in the face and head, which cut by Dow in his face. It is there, Lordship, in face. If I look into the medical post-mortem report, tongue and head, and some of his teeth were lying on the ground. These teeth were, Lordship, also corroborated by one of the witness, Lordship, PW5. He also stated the same thing, Lordship. He saw. Moreover, if we look into the PW's, Lordship, or many of them have stated that they saw blood oozing out from the head, Lordship. So it is there. If we look into the postmortem report also, Lordship, is at page 76, Lordship. The deceased has multiple cut injuries with clear margin, skull bone, lacerated bone with fracture, Lordship. So it is on head, Lordship. Multiple lacerated wound of face, so it is on face, neck, and head region, Lordship. Moreover, in the scalp area, Lordship, sharp cutting wound of scalp and scalp bone, gapping of the skull wound seen. Moreover, Lordship, in page 77, mouth, that abdomen part, Lordship, mouth and esophagus, lacerated injuries are there, Lordship. Moreover, if we look at the injury, muscle, bones, and joint, multiple stab injuries with clear-cut margin, Lordship. So I want to focus only with these things, Lordship. So commotion is there. Injuries are also seen. Moreover, if you look 164 FIR and the deposition of the evidences, on most of the things are similar, Lordship, on vital points, Lordship. Only the thing is that he has stated that his lathi is there. But in the FIR, he has stated the sharp weapon. In the 164 statement, he also stated about the sharp weapon.
Dow,
Lordship. And one of the witnesses also has stated that Dow-like weapon, Lordship. It is there in PW5, Lordship. So I want to focus only these 3 points, Lordship. Injury is there, eyewitness is there. So even if the eyewitness sees something, motive is not required, Lordship, on that point. If eyewitness is there, Lordship.
but are the versions of the eyewitness PW4
Lordship.
consistent without even going to the aspect of corroboration by others?
Lordship.
Are there, and PW3 does not even make a passing reference
Lordship.
of PW4.
Lordship.
PW4 claims that he ran to the house of his moha,
Lordship.
woke up his aunt,
Lordship.
aunt called his uncle. They all came out with an earthen lamp
Lordship.
to the place of occurrence where they found the body
Lordship.
in an injured state. PW3 does not even say anything about even a passing reference of PW4.
Lordship.
He said, on the other hand, said there was a commotion. Wife woke up, then wife called me. I went,
Lordship.
and there were other people.
It's true, Lordship, but on the material facts, on the point of how he can describe the Lordship and what the injuries are, if he is not present at that point. This PW4.
No, injuries, PW4, see, he did not die there on the spot. He was taken to the hospital.
Lordship.
Injuries could have been described by anybody who has seen him, even at a later stage.
Moreover, he is, Lordship, moreover, he is the informant, he is the
No,
eyewitness.
in the doc,
and-
why did he say something wholly different from what he has stated in the, he's the informant. He has
Lordship.
made 164 statement. Those documents were, we presume that it was within his, very much within his knowledge, not within his knowledge.
Lordship.
He was refreshed with those statements. He's a PW, a star PW.
Lordship.
And as a witness in the doc, he says some other weapon, lathi,
Mhm.
and that is the substantive piece of evidence.
Okay.
What he says in the doc. Others are all supportive,
Okay.
but what once says something on in the doc, that will be taken into consideration. Because that is subjected to cross-examination. Others,
So it is true. Moreover, Lord Chief, he is also have injuries on his eye, Lord. It is also corroborated by another witness, Lord. His eyes are swollen,
no, that doctor has examined him.
Look.
Doctor has come,
Lord Chief.
who has examined the informant.
Another witness is also there, Lord Chief, PW5.
PW8.
PW8.
All. PW5 also stated the same thing, Lord Chief. His eyes are swollen.
Who is 5?
PW5,
Brother of the deceased.
Lord
Yes.
Chief.
Which page? Page
Lord,
16?
Page 15, my lord.
15, 1-5.
Lord Chief, the last part. Last two lines. The accused also assaulted artist diffuser on his eyes, and I noticed swelling in his eye. So he's injured, Lord.
It was the main problem at all. 10 বছর পিছন থাকতে গেছে 2009 এর incident 2019 not happened.
This is reason for the
Lucky 2009
taken.
কিন্তু দেখিয়েছে FIR কি করেছে কি 164 কি করেছে প্রেজেন্ট করবে মাঝে মাঝে থেকে এটলিস্ট প্রসিকিউশন দেখে তো আপনার ভার্সন দেয় করি বলছে
That depends on PP. PP is directly broken by this has because of
delay, huge delay, 10 years. Have you noticed the date when the evidence, the time period from the date of the incident and when evidence were recorded? Examine, these are material, these are significant points. When was the incident?
Incident 14, Lord Chief.
2000?
2009, Lord Chief.
Depositions recorded
2018, my lord.
2018.
1918, 98, not 18, 19.
Okay,
PW5 was recorded in 19,
Lord Chief.
August 19.
But 164 statement is, I think, Lord Chief, 2009.
That is, that 416 is immediately.
Lord Chief.
Incident is
Immediately,
of 1415 and 164 was recorded on
21st of December.
yes 21/12/2009.
Yes, my lord.
Just immediately.
So it would so that sharp weapon were matching.
Lord Chief.
After 10 years, he says Lathi,
Lord Chief.
but all said and done, the defense would definitely take an advantage of this. Why and why not? You have to prove beyond all reasonable doubt.
Lord Chief.
Yes, what else?
Moreover, Lordship, PW3, immediately after the incident took place, he saw that his condition was very critical, Lordship, and he fell down immediately after the blow, Lordship. It is in the PW4 also statement, the eyewitness. That means I want the intensity of the hit, Lordship. That blow immediately fell down, and his condition also very critical, Lordship, on the vital part, Lordship.
That is PW4.
PW4 also stated that, Lordship,
Then
that
who
he
is 3?
fell down, Lordship.
Who is
Though it is
PW3?
though it was on Lathi, he has stated, but he fell down immediately, Lordship. And PW3 is the witness that Lordship, his relative, Moha stating, Lordship. Immediately when he went to that place, he saw his condition was very critical, and I saw blood oozing out of the back of his head, Lordship. So it is must have been a severe blow, Lordship. It cannot be with a lathi, Lordship. If it is the stove, it cannot be with a lathi, Lordship. Immediately it has come, Lordship.
No, if there was blood oozing out, then there has to be some
Sharp
weapon which is sharp.
Lordship. I want to focus on that point, Lordship. Because this is an independent
But
witness,
your star witnesses said Lathi.
Lordship.
PW5 has said that the deceased and the appellant were found to be having alcohol
Lordship.
in the evening
Lordship.
in his cross-examination.
Lord. It is true, Lord.
Mhm. The conviction is based on what?
That is the star witness.
How this has been taken care of, the inconsistency by the learned judge? Mr. Tiwari?
My lord, page 55, my lord. Para 41.
No, was this point raised? Definitely would have been raised. Description of the weapon. Was it raised or not raised? That even the description of the weapon as a lathi is not matching with the medical evidence, which indicates use of a sharp weapon. And PW4's version itself is not matching. Mr. Das,
I am looking into the.
page, paragraph
Yes, yes.
41, page 55. After he almost verbatim recording the evidence of
PW4.
PW4.
Yes, my lord.
As follows, not verbatim recording, it's a quotation.
Yes, it's a quotation only, man. Of the earlier thing. In para 45, page 57, my lord, the defense has taken the previous enmity part, my lord. That
Yes.
the position nowhere says that the Eastern case
Quotation
was
is
due to
not,
previous
it will
enmity.
really
That
give
part
the
has
quotation
been
useful.
taken in para 45, my lord.
41 quotation use করবো না লাগে আছে তো he বলি করেছেন third person লিখি it's almost verbatim
Yes,
recording,
verbatim
it's not
recording.
quotation because the
Yes.
expression used is he is the informant.
Yes.
The inverted comma should not have been used.
Yes. And the next part of discussion starts from page 62, my lord, para 50.
62
Page 62, para 50, my lord.
50.
Yes, my lord.
Oh,
Ignoring the
oh,
substantial.
64
বরাবর প্রাথমিক information.
একটু ভুল হবো না ভুল 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 ভুল। One 64 is consistent হয়ে থেকে কতটা বেড়ে গেছে 164 is not consistent with the description of the weapon so far as evidence is concerned.
164.
What a position.
60.
What is it in page 50, paragraph 50?
The
32.
page 50, para 50 strictly says that it's not a case of circumstantial evidence, rather it is a case of direct evidence, since the eyewitness was there. However, my lord, at page 65, para, my lord, 58, my lord, even the learned court below also states that although the alleged weapon of assault could not be recovered by IU, but as the PW4 has deposed that the accused has caused injury to the disease with a dao, and as such the injury of the disease is corroborated by MO. Now this dao, for the very first time, the trial court has got by itself, dao, whereas nowhere the dao has come up.
Material exhibit object.
No,
Doesn't-
it's not. It's written like this, brother.
MO?
Although the alleged weapon of assault could not be recovered by the IO, but as the PW4 has deposed that the accused has caused injury to the disease with a dao, and as such the injury of the disease is corroborated by the medical officer, it can be believable and reliable that the disease was assaulted with a dao, which is a sharp cutting weapon. Whereas the dao nowhere came in the entire evidence, my lord. That it was a dao, it was a knife, or it was a kukri, or something like that, my lord. No description of the, my lord, weapon was spelled out by any of the witnesses, my lord. Only the IO speaks about that. He tried to search out the dao, but he could not find his house. And thereafter he says that he might have thrown out in the jungle, my lord. para 58, case 65.
It is a full good now, page 58 to para 58. Page para 58. Thus, from these evidence appear with 3 4. मैंने क्या हेल्प की एविडेंस कौन है ना शार्प कटिंग कौन है ना
PW for 164.
164
And thirty let's say 164.
is the evidence. How what is your take on the observation, the findings at page paragraph 58? Please read it aloud.
On perusal of the material evidence on record, it is found that in the instant case, PW4 has categorically stated in the FIR and the statement recorded under 164 that the accused has assaulted his deceased uncle with a dao. So now, my lord, how come it is assaulted through a dao, my lord? I could not find anywhere in the evidence.
No. See, what is the
FIR
FIR and 164?
Yes,
He has not talked about the evidence.
evidence. He's not talking about the evidence. my lord. In the court.
FIR and 164, Dow is there.
Sharp cutting
Sharp
weapon.
cutting weapon, Dow. Let us assume it's Dow.
Okay.
Thereafter.
The PW6 MO has corroborated the FIR and the testimony of the PW that the injury of the disease was caused by sharp cutting weapon. The PW3 and 5 who saw the dead body of the deceased Manu Hasnu have also deposed that the back of the head of the disease was bleeding. Thus, from this evidence, PW3, 4, 5, and 6, it is crystal clear that the injury of the deceased Manu Hasnu was caused by sharp weapon.
Yes, wait for a moment here.
Yes.
Does from these evidence of PW3, PW4,
Yes, madam.
where is the evidence of PW4 discussed? Learned judge has not discussed PW4's evidence. He has
Evidence.
only mentioned the version in the FIR and 164.
164.
That is not the evidence.
That is not the evidence. Because the court evidence is the vital evidence.
Then from where he comes to a finding that from these evidence of PW3, PW4,
5 and 6.
5 and 6 is okay. 4, where is the evidence of PW4? What is the relevance of 164, Mr. Tiwari?
Well, the relevance of 164 is, my lord, since he is an eyewitness, my lord, he is spelling out the incident, my lord. But that 164 has to be corroborated, my lord, with the court evidence, my lord.
What is the case law?
My lord, that case law, my lord, I did not got, my lord.
Why?
My lord. If a day's time is allowed, my lord, I'll just place that part, my lord.
The evidence needs to be corroborated by 164 or 164 has to be corroborated by evidence.
My lord, the 164 has to be corroborated with the evidence.
That's the reverse. Evidence has to be corroborated by 164. Your evidence is something else.
Yes.
164 is something else. There would be case laws.
No, there
That
are,
is,
my lord,
if-
my lord, but there are.
If there are certain inconsistencies which may form a decisive factor in the decision-making process, what will prevail, or can it be totally ignored? Or how do you reconcile? Can it be harmoniously, um, can there be a harmonious construction?
My lord, generally the law is otherwise says that if there are two views possible, the views which is favorable to the
No, that is
accused.
a different principles of jurisprudence. Two views, possible views to favorable towards the accused is always to be
Okay.
taken. That's a different on the presumption of innocence. Here we are on the aspect of 164 and substantive evidence.
My lord, one day.
It's up to you. You're taking whole day and you're asking for time now. Yes, Mr. Das, what case law on this? How do you reconcile 164 and substantive evidence?
Lordship, on that point, Lordship, Lathi, it is stated in PW4. However, in 164,
Sharp weapon.
it is sharp weapon. Lord.
Yes.
However, it is
Do you
substantive
know why this has happened? Because of the time gap.
time gap. Lord.
1 decade.
Lord.
And also because of some, what do you say? Lacuna on the part of the prosecution. PP should have made him aware of what was the circumstances.
Lord.
It is the informant, and this is the 164 statement. Kindly read it, or at least I read it to you. It was
Shown
not
to him,
shown to
Lord.
him. After 10 years, it may be
Lord.
possible.
Because 164 is very recent one, Lord.
Sometimes easy to want to put in something. Anything else, Mr. Das?
There is Lordship, evidentiary below 160 only for contradiction and corroboration, Lord. First, main evidence is not yet, Lord. This is the difficulty, Lord. But still, I have looked into it, Lord. This kind of happen. What will Forest.
From
Forest area.
forest, my lord.
Forest area. At 3 p.m. Died on
3
at
p.m.
3 a.m. 3
in
a.m.
the
died
daytime.
the deceased. At 3 p.m. on the same day, he was arrested. He was in forest area. But
Physical. And my lord, that area is completely of forest area only, Manja, my lord. While going to Dimapur, we generally find that particular jungle, my lord, the area, Keroni, my lord. Manja, Doboka, my lord, the area, my lord, entirely a jungle area. They collect, my lord, the branches of trees, my lord, for cooking and other.
daily wage earner. Daily wage earner. Yep. Correct.
No, my- Yes, my lord. 5, he was in Manja, my lord, on the day of alleged incident. He only reached the, but he, my lord, as per his deposition, he directly went to the hospital, my lord. Hospital. Yes, my lord. One says true, my lord. My lord, PW2. Yes, co-villager, my lord. I know the informant and the accused. The page, my lord, 10, my lord. That took place in the year 2009. I heard from the villager that Manu Hasnu was. Manu Hasnu brought him to. He only says that he went there thereafter, my lord. But that apart, nobody has said anything. Nothing was there. Mm. Yes, my lord. PW4 at page 14 says that he, along with his aunt, also went to the hospital. Page 14, my lord. Cross chief part, my lord. Line above, fourth from the top, my lord. I also came to the hospital as I sustained injury. No, Well, later my uncle Fanilal Diffusa and villager called a 108 ambulance, and after arrival ambulance, my injured maternal uncle was taken to Diffu hospital, Diffu government hospital. I also came to the hospital as I sustained injury in my eye. He's separately gone. He has gone separately, man. Yes, a company. PW6, my lord. The postmortem doctor, my lord. And
No, no,
oh, 8, my lord. PW8, my lord. Page 21, my lord. The report is at page, my lord, 82. Sorry, my lord. Nothing, sorry. The report is at page 86, my lord. Injury report. On the next day, my lord, 15. 7:30 in the morning. 9:30. 9:30, but he says 7:30. PW4 says 7:30, whereas the report of her 9:30. 9:30. Page 1, my lord. Column number
Page
3,
one.
my lord.
3.3.
Page 1, my
One.
lord. Column number 3, my lord. Information received
Time 9:30.
9:30 a.m. PW8, my lord. 21, my lord.
My lord, first submission is that my lord, the evidences are sought to convict the accuser.
What is proof beyond all reasonable doubt? What is a reasonable doubt?
That my lord, PW4,
What is the meaning of reasonable doubt? Are all doubts reasonable? Or would come into the way of convicting?
my lord, to my understanding, my lord, reasonable doubts are those where my lord, my lord, my lord, those which creates the presence of a particular person at the place of occurrence, my lord, that negates the evidence
No,
adduced.
not on the presence of, we are not on the aspect of there being an eyewitness. What is the meaning of reasonable doubt?
That
On the
the
context of nature of requirement of proof.
well, with contest to this case, my lord.
Not the case. Normally, what is a reasonable doubt in the context of criminal jurisprudence? The nature of proof, requirement of proof. You said its proof
That
has to
with-
be beyond all reasonable doubt. What is a reasonable doubt? What is the meaning of reasonable doubt? Very close to it. Okay, we close this. But we did not get the answer from you.
Well,
No
Well,
assistance from your colleagues. Mr. Das, what is reasonable doubt?
In my full knowledge, Lordship, I want to say that it should not be beyond shadow of doubt. Doubt may be there, but it has to be reasonable, which hits the core of the case, Lord. If the doubt which hits the core of the case, Lord, should be like that. It should not be beyond shadow of doubt. Doubt may be there. It is not that it should be beyond shadow of doubt, Lord.
Will
Doubt
any,
may be there.
will any doubt or any suspicion
No, Lord.
come into the way of conviction? What are those doubts? What are those conditions which may form a barrier to convict a person?
Those doubts which,
Because speculation will always be there.
Lordship, that will be there, Lord.
This might have happened, this
Might.
could have happened.
But it should hit the main
What has
core of
actually
the
happened,
case.
nobody knows.
Core of the case, it should be hit, Lord.
You found something.
My lord, in that, my lord, generally we say that in all human probabilities, if the person is found not to have committed, but there are hypotheses that he might have, my lord, committed the offense, then my lord, a doubt is created. If I have the, my lord, like my
See,
lord,
here is a
in
case,
Sarat-
here is a case where admittedly there is an eyewitness. How far you are relying upon the evidence of the eyewitness, that's a different matter. It is not a case of circumstantial evidence,
Correct.
wherein the aspect of doubt would it would be very natural to raise some doubts. A person has seen the incident of assault and the death caused, and thereafter you are trying to put in the aspect of doubt.
Doubt.
So your burden is on a much higher footing.
That
That in spite of there being an eyewitness, I am still trying to making an endeavor to raise a doubt, reasonable doubt.
sir.
What was the cross-examination of to PW4?
Cross-examination of the
PW4, the eyewitness?
PW4 was that there was no previous enmity between them. The cross-examination, I'll just.
On his evidence that he has seen the incident, was there any cross?
No, my lord, that cross was not there.
Don't you think that the foundation should have been shaken at least?
Very correct. At least that part should have been asked for from the witness matter. Well, to discredit the evidence of the
Yes.
PW4, well, that question should have been put to the
While you had
PW4.
accompanied the deceased, who were with you?
Who are with you?
How did you go? Let us see the cross of PW4.
PW4, my lord, cross-examination is at age, my lord, 14, my lord,
1-4.
1-4, my lord.
Yes, please.
We did not have any quarrel with the accused.
There is no cross at all.
No cross at all with respect to whether how they met on that day, they had food at their place, thereafter they came together. Nothing on the point whether he is not the eyewitness today, he was not accompanying the person.
Regarding his presence, no question is there, Lord. To deny his presence.
Chief 2 successful percentage equals Chief 2. Place of occurrence.
It is not examined. You can have that statement.
Uncle Nakorato we can ignore. If uncle corroborates that yes, we came at
But
our.
let's get it there. Uncle same man says that he came to me about the incident from other relatives.
And he was sleeping and his wife woke him up and asked him to go.
He has totally led the story.
I got up on reaching the place. Thereafter, I called the people residing nearby. Thereafter, কোনো নাসিলিটি PW3 হইছে প্রমোশন হইলে 200 মিটার যে মানে দিকে কম না খরচ করে নিব কোনো রাতি হনিব পরে 200 মিটার হনিলে পরে হনিয়ে গেছে I got up and কি বলেন my wife woke up and told me that promotion near our house and asked me to go. I got up and entered place of occurrence which is 200 feet away, meters away. On reaching the place of occurrence, I saw so-and-so on the ground beside the Kacha road. I recognized him as my brother-in-law. Though he was not there at time, his condition was very critical. I saw blood oozing. Thereafter, I called the people residing thereafter. Thereafter, I called the people residing in the and brought to my house. Thereafter, people of my neighbor called an ambulance over phone. এইটো ক'ব পাৰিলে হয় তেতিয়া মৰা নাছিলে হেৰিৰ নাম কৈছে মাৰা বুলি কৈছে এটা মূৰত দুখ পাইছে মেবি ক্লোজ কৰি দিওঁ okay close কৰি দিওঁ Tiwari. You're an amicus, Mr. Tiwari. Amicus.
Yes.
Okay, amicus. And KK does learning the PP. Hearing is concluded, judgment reserved. Okay. We'll consider.
Four to six.
Was there Mr. Kyle was here around?
Kyle followed that.
4 to 6.
NCB case.
We are very unfortunate in this case, Lordship. Since 2 years, we could not complete the hearing. Hello.
It last night. But he was sitting all around. Where is he gone?
Yes, Kyle is also there. Again,
Yes, madam.
again. Ayo. Come, Lord. Without him, it will not complete. It will take time. It will take time, Lordship. Put him. No, let me do this. Start put him. Single and stick. Single.
It's up to you, but madam says that it may not be possible to complete today in 1 hour.
No.
How many witnesses?
6 witnesses.
6 only. So why
But
is it so?
it will long, their deposition long because it's an NCB case, sir. We can start if you're
No,
he's not there. Without him, not possible.
if you're
We
not
are
able to
habituated with
complete,
this.
we do not know how much longer this bench will continue. Fix a date. Press date.
Can it be on Tuesday or like that or Thursday?
Mr. Chaudhary, you are also there.
Yes.
Mr. Kyle was there sitting, but now he's not there. His colleague says that he would be coming, but it may not be possible. My brother has a single bench.
Also fixed the date because my idea on the sovereign date came out of this is on that is
Can't help.
sometime my
Once party hard.
yeah,
also.
party.
Because this bench is also not very certain bench.
Next week this bench is not.
No, we do not know. Okay, but tell us a date. Madam, we are fixing a date. Come.
Okay. Date given.
Mr. Kyle.
Huh?
It may not be possible for completing it today. Because my brother has a single bench. But if you are very keen, we can fix a date of your convenience.
We are keen, madam. He is not. But
He's also keen. He was sitting.
yes,
Yes, sir,
anyone.
it's here.
Next Tuesday or Thursday morning.
But he at the crucial moment, he had gone out.
No, Lordship,
When the earlier case was at the peak, he was sitting. When it was about to be complete, he had gone out.
actually,
I was
So
called
you may
back.
be correct. He's not very.
Depends idea also, my lord.
Sir, legal point. paper.
I
maybe-
think it will not take much time, my lord. I hope, my lord, you feel lordship. And then the next week, my lord, I repeal your lordship, my lord.
No, madam says only 6 numbers of it.
6 members,
Yes,
only one legal
One-
point involved Lordship here. 52A is not compliant and honorable
Very
apex
short
court
point otherwise.
in
What is the non-compliance of 52A?
52A samples
Wow.
must have to, some samples must have to collect in presence of the
Magistrate.
magistrate. That is not
not-
followed.
What
that
about
is-
the notification of 89?
89 notification is also there.
One
And-
of 89?
One of 89 is there, but Lordship, this is a case after Mohanlal Lord.
After Mohanlal. Which
No.
one Mohanlal? Union of India versus Mohanlal? Or Mohanlal versus?
Union of India versus Mohanlal. In 2016, PSCC. So Lordship, thereafter also our division bench, his Lordship also passed a similar type of judgment. Latest judgment in fourth.
But that Mohanlal, it is only recommended for taking care. And the amendment came much later, 22.
So that is true, Lordship, but after that also there, we need to discuss on that point also, because all the apex court judgment, other judgments also there. Latest judgment also there, if not followed in 2000 years, 2000 case
See
also.
the subsection first. One gives power to the central government to issue notification. Accordingly, 1 of 89 was issued. There is no ambiguity or any issue on this, on such powers. Now, that power has been held to be in Mohanlal. An observation made that it appears to be in contrary of the statutory requirement, wherein sampling is required to be done in presence of the magistrate. So it was left to the authorities to pass necessary orders. And ultimately in 2022 it was done.
That notification in the year 2022 December. But before that also 2000 case in Mongilan and all, Honorable Apex Court and one latest judgment, Honorable Apex Court passes judgment if not followed. In that case, 89, though 89 is there, if not followed in presence of the measure, because Act says, Act is enacted in the year, this section inserted in the year 1989, Lord. 89. So that is why it must have to follow by them. So Act says, Lord, though notification is there. Huh? So that is why.
Tell us when? Thursday next?
Yes.
Is it okay? Paucity of time did not permit the matter to be taken up today. Sarah, as requested, list for hearing on when about?
14.
14th.
Obliged.